Modern Real Estate Practice, page 380. To protect owners of existing structures from the massive expense of extensive remodeling, the ADA recommends reasonably achievable accommodations to provide access to the facilities and services. New construction and remodeling, however, must meet higher standards of accessibility and usability because it costs less to incorporate accessible features in the design than to retrofit. Through the law intends to provide for people with disabilities, many of the accessible design features and accommodations benefit everyone. The property manager typically is responsible for determining whether a building meets ADA accessibility requirements. The property manager also must prepare a plan for retrofitting a building that is not in compliance when removal of existing barriers is readily achievable and can be performed without much difficulty or expense. Some tax advantages may be available to help offset the expense of ADA compliance. ADA experts must or may be consulted, as well as architectural designers who specialize in accessibility issues. In practice, the U.S. Department of Justice has ADA specialists available to answer general information questions about compliance issues. The ADA information line is 1-800-514-0301 TTY 1-800-514-0383. Existing barriers must be removed when this can be accomplished in a readily achievable manner with little difficulty and at reasonable cost. The following are typical examples of readily achievable modifications: ramping or removing an obstacle from an otherwise accessible entrance, lowering wall-mounted public telephones, adding raised letters and braille markings on elevator buttons, installing auditory signals in elevators, reversing the direction in which doors open. Alternative methods can be used to provide reasonable accommodations if excessive or extensive restructuring is impractical, or if retrofitting is unduly expensive. For example, installing a cup dispenser at a water fountain that is too high for a person in a wheelchair may be more practical than installing a lower water fountain. In practice, federal, state, and local laws may provide additional requirements for accommodating people with disabilities. Real estate professionals should be aware of the full range of laws to ensure that their practices are in compliance. Equal Credit Opportunity Act. The Equal Credit Opportunity Act, ECOA, prohibits a lender from denying a loan based on a person's race, color, religion, national origin, sex, marital status, age, or receipt of public assistance. The ECOA affects the property manager in several ways. A manager should use the same lease application for every applicant. If a manager requires a credit report from one applicant, the manager should require credit reports from all applicants. The manager should be consistent in evaluating the income and debt of applicants and in determining whether to rent to an applicant. A complete copy of the law can be found at www.fdic.gov/regulations/6500-1200.html. Guiding principle: what you do for one, do for all. Page 381. Fair Housing Act. The Federal Fair Housing Act and its amendments prohibit discrimination in the sale, rental, or financing of housing based on race, color, religion, national origin, sex, familial status, or disability. Property managers need to ensure that their marketing practices do not violate fair housing laws. For example, blockbusting and steering are prohibited. Blockbusting is encouraging people to rent or to sell a property by claiming that the entry of a protected class of people into the neighborhood will have a negative impact on property values. Steering is the channeling of protected class members to certain buildings or neighborhoods. The Department of Justice has information on fair housing issues at www.justice.gov/CRT/about/HCE/housing_coverage at PHP. In practice, many fair housing complaints are related to property management issues that could have been avoided by treating all rental applicants with the same courtesy and respect. A fair housing training program can be useful at any stage of a real estate professional's career and is often a requirement for license renewal. Risk management. Enormous monetary losses can result from unexpected or catastrophic events. As a result, one of the most critical areas of responsibility for a property manager is risk management. Risk management techniques. Risk management involves answering the question, what happens if something goes wrong? The perils of any risk must be evaluated in terms of options. In considering the possibility of a loss, the property manager must decide whether it is better to avoid it by removing the source of risk. For instance, a swimming pool may pose an unacceptable risk. Control it by preparing for an emergency before it happens, by installing sprinklers, fire doors, and security systems. Transfer it by shifting the risk onto another party, by taking over an insurance policy, or retain it by deciding that the chances of the event occurring are too small to justify the expense of any other response. An alternative might be to take out an insurance policy with a large deductible, which usually is considerably less expensive. Security of tenants. Recent court decisions in several states have held owners and their agents responsible for physical harm that was inflicted on tenants by intruders. These decisions have prompted property managers and owners to think about how to protect tenants and secure apartments from intruders. After the terror attacks of September 11th, 2001, managers of commercial properties also have increased awareness of security issues. A professional security analysis can help identify areas of concern and suggest possible remedies. Memory tip: the 4 alternative risk management techniques. Use the acronym ACTOR. A is for avoid, C is for control, T is for transfer, O is for or, R is for retain.